The detention and seizure process is a complicated one. This is a snapshot of the seizure process that U.S. Customs and Border Protection, CBP, uses to handle the administrative seizure process. If it looks complicated, that's because it is. You need to ensure you have an expert familiar with the CBP process to trust. First, did you receive a detention notice that looks like this from CBP? Let's go over what this notice means. U.S. Customs officers at all 328 ports of entry have the ability to stop and search persons or merchandise and make admissibility decisions. If the U.S. Customs officer believes merchandise should be detained, the Customs officer is required to send the importer a notice of detention form no later than 5 days from the date of examination. It's critical to have export counsel assist you during the detention phase. Your #1 goal is to avoid a lengthy seizure case. How can Diaz Trade Law help? Diaz Trade Law routinely provides expert counsel to identify the rationale for detention and discuss the legal rationale for release with U.S. Customs to assist importers in getting their merchandise back and avoiding seizure cases. If you're not successful in the detention phase and your goods are seized, you will receive a notice that looks like this. What does this notice mean? U.S. Customs may seize goods if they are contrary to law. If your merchandise is seized, you do have options. In your seizure notice, you are provided a fines, penalties, and forfeitures FP&F case number and assigned a paralegal. The paralegal will send you a seizure notice and you have 30 days to respond. A response is called a petition. A petition should only be prepared by an expert in customs cases. A petition typically contains your legal arguments and the valid reasons why U.S. Customs should release your merchandise back to you. How can Diaz Trade Law help? I, Jennifer Diaz, am a board-certified expert in international law and specialize in assisting companies with U.S. Customs seizure cases. I understand the policies, procedures, and practices of CBP and will always clearly advise you of your options. My firm, Diaz Trade Law, will not only help you with your current seizure, but I take the extra step to also advise you on pre-compliance to make sure your merchandise complies with all relevant laws and regulations for your next importation. In some instances, for example, if you import counterfeit goods into the U.S., whether it's knowingly or even unknowingly, U.S. Customs has the authority to issue monetary fines against anyone who facilitates the attempted introduction into the U.S. of seized and forfeited counterfeit merchandise, where the trademark is recorded with U.S. Customs. This fine is in addition to the seizure and forfeiture of your imported merchandise. For example, in this case that you can see, a client came to me with a penalty from U.S. Customs in excess of $4 million. The penalty was for an underlying counterfeit importation. I was able to successfully assist this client in mitigating the $4 million penalty case down to $4,000. I have many other successful past results on DiazTradeLaw.com. Every case is different, and each has to be evaluated on its own merit. Let me review your case and advise you if I can assist you. I have many blog posts on this topic as well at DiazTradeLaw.com. Let me be your customs and international trade law expert. For more information, please visit DiazTradeLaw.com.